Ms. Kaser, Judge Kulik, Mr. Page, and Representative Robbins, which is 5 members, bringing us to quorum.
Thank you so much, Mr. Vogel. And with quorum, I think we have the most recent meeting minutes posted on the task force website. I think the last meeting was on the 23rd of August, and it has been posted. And if does anybody have any corrections, alterations, concerns regarding meeting minutes that were posted? Great. Seeing no hands raised or concerns, we're going to adopt those meeting minutes as posted. Thank you for doing that, Mr. Vogel. So today we're going to continue a discussion, and I know that obviously Representative Robbins had been busy with a lot of other things, and maybe just a quick update on where we're at. We are looking at currently in the 7-year disqualification period, the list of criminal offenses that would disqualify an individual. So these would be misdemeanors, conviction cases, and currently the disqualification period is 7 years. We had been plugging these in to determine whether or not, under a different structure, if we had a structure that was consistent with a lot of the federal law in the area, the Adam Walsh Act and so on, where they really have 2 groups of disqualification periods, a 5-year disqualification and a permanent disqualification. How would these fit in? And the 3 areas that we are sort of talking about is whether it exists at all, whether it should be a disqualification, whether it should be a 5-year disqualification, or if it should be a permanent. We hadn't come up with any permanent disqualifications for misdemeanors, but we were going through the misdemeanor list. Mr. Vogel, could you pull up the list of misdemeanors as we were going through them? And we have updated them a little bit to show some data that we've received. Okay, so scrolling up a little higher, if you could, you can see we kind of were at the 15th listed offense, which was coercion. And the way this is set out now is obviously we have the type of offense listed on the left side, the statute that it's listed under, and the 2018-2019 numbers are the numbers from the Department of Human Services on how often that offense is used for a disqualification. So, for example, we'll just look at the top. Wrongfully receiving public assistance had in 2018 46 disqualifications, and then in 2019 64 times the department had disqualified individuals based on that. So we thought it was helpful because, like, if you look at number 14, assault on an unborn child in the 3rd degree, you can see over the 2 years that we got data from the Department of Human Services, there were no incidents where that conviction was used to disqualify. Just using it to provide more information. And then the one thing we added to this chart too is just a definition to the far right. I know that we were using Mr. Page and Judge Kulik to grab their statute books and read it, but we thought we'd make it a little bit easier. Any questions about the format that we're using now as we move to discussions of specific disqualification crimes? All right. So again, what we're looking at right now is, are we going to remove it? Is it going to be a 7-year or something else? The next one we have is number 16, violation of a protection order. And as you can see, there are no situations where the department had used these. And I think under this type of protection order, it's more of a contempt matter but not an order for protection. Judge, have you had any of these pop before you over the years?
A violation of an order of protection, yeah.
Yeah, see, I don't. Okay, so then this is the one where it's actually under the contempt provisions of the court.
Well, no, I have seen that, but as a criminal charge, you're right. No, the ones that are charged out with regularity are the DANCOs, the domestic abuse no contact orders. And when those go into place, in fact, it's usually with a charge of a domestic assault. And I almost always put them in place. And I always tell the defendant that violating a domestic abuse no contact order can result in further criminal charges. So yeah, I actually have not seen violation of a protective order come through, sometimes of an HRO, but it's mostly the DANCOs, the domestic abuse no contact orders. So yeah, I'm not surprised that's zero.
Yeah. Mr. Page, do you have any thoughts, or I open up to anybody else?
I mean, in my mind, this is a situation that typically involves harassing behavior. They have been told not to do that, and then they continue to do it. It should be on the list.
As a 5-year? Okay. You don't have any belief, Mr. Page, that the misdemeanor version of this should be a permanent of any kind, though?
If it's sentenced as a misdemeanor, I don't think so.
Okay. Anybody have concerns either way? Is this something some people think that should be removed, or think there should be a different disqualification period?
This is Kristen. I just had a question. So have we adopted this framework of only 5 years, or what was this under the old regime?
7 years. So under the current statute, any misdemeanor that's listed here universally has the same disqualification period of 7 years. And so whether it's a low-level theft or an assault that is a misdemeanor, it would have the 7-year disqualification.
And as a body at an earlier meeting, it was decided we would change all 7 years to 5 years?
Yes, it has been. We've looking at changes, and one of the changes that we came up with was looking at following kind of the federal rules a little bit more and what other states have been doing, which is closer to this 5 and permanent, and then doing our own assessment and determining what that would look like, and then looking at it again as a whole. There's been no 100% commitment to it, but has been probably, I think, without a doubt, the format moving forward that has been probably most warmly received.
Thank you.
And I think, Mr. Chair, it's worth mentioning that the 5 years was more reflective of the data that tells us if you're not reoffending within 3 to 4 years, then you're unlikely to reoffend, again. And so to punish people for another 3.5 to 4 years after disqualification, or I'm sorry, as a disqualification period, seemed excessive.
The other thing too, Representative Robbins, like, I don't know that we've talked about 5 years from when. And so, right.
That was going to be my next question. When does the clock start?
Yep.
It's and what we decided was there were a lot of other questions to kind of figure out. And the first look was we decided to look at the offenses under it, then go back and figure out when it starts, then actually go back again and see if that changed anybody's mind for any of it was a little bit of the chicken egg, which one was going to come first. And so this is sort of just how we decided to move forward, because some of the ideas had been, date of offense, date of conviction, a date off court supervision. One thought, and Mr. Page had worked on this with the child foster care licensing, that it might, if a person has any incarceration period, that it would you get no credit for being incarcerated as your time, but that would not involve a lot of these misdemeanor offenses because they're not really incarceration crimes. Did I say that correctly, you think, Mr. Page? And I don't like to obviously speak for you, but if I misspoke, please let me know.
That is correct.
Okay. Anybody else have anything to say on kind of the framework that we're looking at, or any the violation for a protection order, which I think we've agreed would be a 5-year?
Just a little more on the timeline for Representative Robbins' benefit, because she's been busy in session. Right now, Representative, we're still working on our backlog, and I have cases going to trial even misdemeanor cases that have had to wait for felony and gross misdemeanors to be in front of them, that are 3 and 4 years old. On some of them, I have defendants who have been on pretrial release conditions and have been flawless. And to think that the clock starts ticking again when, through no fault of their own, the court system shut down, and they've already been waiting 3 years to even, get to this point. So I've been a big advocate of date of offense. If somebody has reoffended since the date of offense, we'll know. That's why I'm an advocate of that, because the circumstances these days seem to warrant it.
Thank you, Judge. So why don't we move on? And Mr. Vogel, if you wouldn't mind putting in the 5-year. Mr. Vogel is in a difficult spot. He's at a delayed on a flight in New York, but he's still plugging away and working with us. So appreciate it. And medical assistance fraud is essentially, it's one of the theft cases that are very prevalent in the misdemeanor portion of the statute. There were 0 misdemeanor cases in the last 2 years, though. Certainly, I think there might be more at a higher level than I would assume, but the numbers are non-existent for medical assistance fraud. What are people's thoughts on medical assistance fraud as a disqualifier? And there might be the other thing to remember is license holders who have convictions for medical assistance fraud are going to have issues. And this would be for somebody just working in a childcare setting, working in it could be a nursing home.
So what is the dollar? Is it dollar amounts, Max? Is there a dollar amount associated with how they do misdemeanor like other stuff? Or is it how they did it? Like, how do they differentiate?
I'm just looking real quick. The statute listed there does not provide a penalty. I'd have to look a little further. But
Okay.
this strikes me as one of our crimes of poverty that we had said we were not including as a disqualifier, unless there's something unique about this one, like it's related to government funds or something that would make us want to think differently. I'm guessing maybe this is sentenced under the theft statute, which has, many different provisions and leads into, I think, one of the next ones on the list. So maybe it's better to have part of a bigger conversation about that.
This also is just the attempt, which is why there's no dollar amount attached to it. So it's presenting a claim for reimbursement with intent to defraud.
So like they tried to, but didn't get away with it?
Yep. And I think the reason that there's 0 is you have to prove intent instead of simply a mistake. If I'm applying for my mom for medical assistance and I don't have the value of everything right, not only does it have to be proven that it was incorrect data, but there was an intent to defraud with it. And I've never seen one come into court. And so it's not really surprising that it's there. When people actually defraud and intentionally defraud and intentionally give false information in order to get governmental benefits, that's a whole different deal. This is just the attempt making a claim with the intent.
I feel like this one could be removed from the list.
Yeah, I do agree with that. Where are others on this?
Especially when it's affecting nobody.
So I have a question. Sorry. Do you know how many of these cases were being processed? Because the 2 years we're looking at, I guess 2019, they were probably running at full steam over at DHS, but in 2020, I'm assuming they weren't. So are these good numbers to base our decisions on, or is there
We have
a longer
20
stream of numbers?
We have 2018 and 2019. So COVID wasn't really.
Okay. Sorry, I thought it was 2019 and 2020. Okay, then those are
I
accurate,
may
I
have
would say.
said that. And actually in 2019, the numbers go really high because the state took over additional roles for doing more background studies. So that's a really big year. It's almost twice as many as they did in 18. So I think anything that's stuck from 18 to 19 is a pretty good number for us.
Okay, thank you.
It's hard to, Representative Robbins, DHS to some degree doesn't keep this data. It's hard for them to gather it. And so, I know that it was hard for them to put this together. So, I think we wish we had 2020 and 2021, but it was hard.
Or back. I would rather have had back a little further because those were COVID years and it was such it was chaos. And so, looking at recommendations, and that's not this group, but what about a recommendation for them to have a data system that they can collect this stuff to disseminate it when legislators and other folks are looking for it? Because it took literally 6 months to get this information to be able to start working with it. That's not an exaggeration.
No, and I think
sorry,
the
Mr. Chair,
department was working hard.
Looking through the dashboard on the Hennepin County Attorney's Office website that we have, I think this would fall under financial fraud or public assistance fraud, both of which in Hennepin County have had fewer than 30 cases prosecuted each year. Most likely public assistance fraud, and there's fewer than 10 of those cases processed every year. So the chances of someone committing this are pretty low, it seems, or that there's evidence that someone committed this is pretty low, it seems, and even less likely that someone's going to apply with this.
In my experience too, you saw when you saw sort of the wrongfully receiving public assistance cases, they were rarely prosecuted at a low number. It was some of the bigger ones. The low numbers were oftentimes written off as overpayments, as a programmatic issue, but not charged. Getting back to Ms. Kaser, and I concur with her on removing medical assistance fraud from the disqualification statute for the misdemeanor level. Are there any individuals opposing that idea?
I guess, Mr. Chair, my only question would be, is if we want to engage in any sort of discussion about whether, someone engaging in fraud or theft with the victim being the government, if that raises any additional questions that would mean that it should be on a list or not. I don't feel strongly, but I think it's worth raising.
What changes it, Max, to you if it's a government program? If we're talking about safety, and I'm just being devil's advocate, if we're talking about, really, we're not talking about whether this is good behavior or bad behavior. It's about whether or not these individuals pose a risk to provide services to vulnerable individuals.
So I think to the extent that they're using government data in systems, and they have seen the taxpayer or the government employer, or not employer, but benefits provider as kind of a monolithic, non-personal victim that they can take advantage of if they're handling funds then for some other institution that maybe they're not able to personalize the victim if there's an increased risk of likelihood of wrongfully obtaining those funds. I'm not arguing that there is. I think it's worth asking. And maybe the fact that I can't argue that it is is an answer in and of itself.
I mean, I just think that we're not, I mean, and are we trying to protect the government, or are we trying to protect individuals from being poorly treated within systems? Because my understanding of the Background Study Act is this is designed to ensure that certain individuals don't have access to people who don't have a voice, don't have the ability to stand up for themselves, and we want to protect them admirably. And we want to make sure that people receiving services do so in a safe environment, free from abuse. But if somebody overbilled the government isn't without a voice. And I actually don't think 99% of the people who do direct care services have anything to do with the billing. It's going to be more of the provider side, which would be licensed and would have different rules and regulations. Those are my thoughts, but anyone else have thoughts on that?
I do have some thoughts on it, but not at the misdemeanor level. I feel like when we're talking about like, you know, medical assistance fraud that somebody attempted, and like, and all these numbers are, you know, super low. Like, when you, I keep trying to scroll down to look at some of the other cases, and I don't have people of that. But, you know, looking at, you know, the folks that we serve, and, you know, you're talking about character, John, and people whose character is in question. It doesn't matter if they're stealing from the government or if they're stealing from grandma, like people who, that, you know, that's their character. Like we have to be concerned. And so,
Okay.
I think, you know, differently, like medical assistance fraud and issuance of a dishonored check where you're writing your own check, and like even receiving stolen property at the misdemeanor level, how easily that you could not have known. I think different when it's, you know, some other stuff. And at the misdemeanor level, I feel differently than I do when it gets to be higher level
Sure.
stuff. So.
Sure. Well, why don't we
We are
just
talking about character, right?
okay. Could you just kind of put in there that we're divided on it? Oh, and Judge Kulik, please.
I think I made the point before that because this is an attempt or submitting something with an attempt, seventh year on the bench, have never even seen it charged, because the charges usually end up with people who are caught having taken the money. And when it comes to medical assistance, it's different than trying to get extra SNAP funds to buy more groceries. You know, that really is, there are crimes of people and financial crimes of people in need, crimes of poverty, but the big like felony level medical assistance that we will get to tend to be the kids who transfer grandma and grandpa's land and money to themselves, and then have the taxpayers paying for grandma and grandpa in the nursing home while they, you know, get away with tens of thousands or hundreds of thousands of dollars in assets. That's kind of what I see a lot more often. And that's a whole different case. So this one, I'm just like, nah.
Thank you, Judge.
Yeah. And I'm not divided. We can take it off there. Like, I feel like as we get to the higher level ones though, it like.
And, you know, with the numbers so low, I feel divided. Sometimes when there's a bunch of zeros, I think, who cares? Leave it in. The other part of me says, well, if there are no numbers, take it off to keep this thing simple and streamlined. I don't have an answer to that, but let's move on, because theft, which is number 18, is it's the biggest disqualifier at the misdemeanor level. of all the cases we have in misdemeanor level. This is the biggest. And we're talking about theft. I think we're talking about $500 or less. And what do we do with that?
When I think about public safety, which first, we want to get people jobs. We need people to fill jobs. Who represents a risk? This is the shoplifting one. And I see a lot of it, and I don't see these people moving on to worse crimes. They're terribly embarrassed, and yeah, they took something from Walmart or the Dollar General or whatever, but it doesn't take much. I had somebody literally take a Hostess Ho-Ho and get charged with a misdemeanor. And should they have done it? No, but man, to think that you're going to be disqualified for that long over it, that just seems really excessive.
Judge, what if you had 3 of them?
Well, that's a really good question. And if there were something besides a 0 and then a 5 and then a 7, we could decide, you know what, look, why don't we put as a disqualifier the normal period of being on probation? When you get convicted of most misdemeanors, you're on probation for a year, because you get through probation and then you do another one and it's a year every time. There's some fairness built in. You continue the behavior, you continue to be disqualified, rather than one that's, good for 5 years. That just seems excessive for one.
Like you were reading my mind, Judge Kulik. This is another one of them. And we talked about this at one of the, I don't know if it was a misdemeanor one, or like, I wish we had a choice that it could be like, once you're off probation for this crime, then it's no longer a disqualification. But I know we're trying to simplify things, right? And so, or one like on your first one, you get a freebie, but consecutive ones, then because theft is another one of those things where like I have some folks where they have sticky fingers, right? And like we need folks in the workforce, and we can't be holding it against them. Like 5 years on these seems really long from release from supervision. Because if you've got somebody that's on probation for a year or 2 years, and then we're holding them for another 5, so that's 6 years crime free before we're done.
Well, and then if you add in Judge Kulik's analysis, where you might have 2-3 years before, I mean, you're looking at 7-8 years. And, sometimes the ones I see on this are, stealing diapers. I mean, there are some poverty ones in here too. That's what I struggle with too.
And how long before they could get this? I mean, the fact that we're holding their employment hostage longer than they could get an expungement for it for.
Yeah, it doesn't make any sense, does it?
No.
I literally had a woman stealing birthday presents for her kid. She'd been homeless and she still stole. But I'm thinking, wow.
So if you have the resources to get an expungement for it, you can get it off your record in 3 years, right? But they can
2-year waiting period.
Yeah. And so, but the way that we have it set up, it's 7 years now. And like the way that we're looking at it right now, it's either none or 5. I mean, that's just the way we're looking at it as a group, but it seems like this is one of them ones where I feel like we need a third option.
I know Ms. Evans is right. We don't want to make this more complicated. We want to make it as simple as possible. And yet it's really a tough one, because there are people who, they should definitely, it's a crime. The shoplift, to steal is wrong.
And
if they would be a great foster care provider for their niece and nephew who were removed from their sister's home. You know, that's the troubling thing to me, is that offense has nothing to do with their ability to give care in certain areas. And I wish there was some way to parse that out.
That's a tough one. Representative Robbins, please.
You know, I'm just raising some questions or concerns on this one. I mean, someone said that, you know, we're barring them from their career, and there are a lot of other jobs that are available in the economy that aren't tied to DHS. So clearly they have other avenues for work if they've committed theft. And I think it's a pretty serious thing. I mean, in my district, I can't tell you the high levels of theft we see all the time. And right now there's zero consequences for it. And one of the problems is these kids are used as like mules, and they're run by older people to go do the retail theft because they know these kids are getting away with it. And I've sat on ride-alongs watching a theft in progress, and they can't do anything about it. And so there's this culture around theft right now that makes me concerned about saying that, well, then they're still able to handle these other responsibilities. Maybe they are, maybe they can bifurcate, but if you're out there committing theft, I'm not sure that there are other jobs open to you, but I'm not sure direct care and treatment are, you know, these social service jobs maybe are the best path for you until you figure that out.
And I mean, the thing I think to remember too, though, is that just because you're eligible or you're not disqualified, it sure doesn't mean you're getting the job. It just allows an employer to hire. The employer's got all of its background that it's going to do, all of its own research on an individual. I don't think it's opening the door all the way to individuals. And, you know, this is just the misdemeanor level theft, which is by law less than 500. And this would only be one time. I agree with you, Representative Robbins. If we have career criminals that are going in and doing stuff, there's no place for that within a vulnerable setting. But trying to find a method that you know, we're talking, you know, 4,800 people that would have been employed or could have been employed and helping out job shortages. And I think a lot of them might be good employees. That's my opinion. Ms. Sherlock, please.
Hi, I'm sorry I was late to this meeting, but I did looked at this sheet before after we were sort of given it as homework. And so I have something written down for theft. And I think we talked about it last time we met, but that it would be maybe a 5-year bar if the theft was a weapon or drugs. We talked about that, right? Because I don't think I came up with this on my own. But I must have thought that sounded like a good idea.
Theft of drugs, I think theft of weapons are higher level crimes.
No, just automatically there are higher level?
I think so.
Okay.
But I will have to double check. Now, I wanted to make the point that Representative Robbins is correct. We have to remember that there are other jobs out there. The only one concern of mine is where we see a huge unmet need, and that is in the foster care system. We have so few foster care providers, and if you are barred because 3 years ago you had a single child incident and you are a relative who otherwise could be a great caregiver, that's not a good result. There is an unmet need there. You know, if there aren't unmet needs, and there are other options for folks where we don't have to worry about, you know, public funds being misappropriated or people being harmed. Yeah, I totally agree. There are other places to work. But yeah, again, foster care and some other things, and adult, special needs adult care. We all know that we're really hurting in those areas too.
Yeah, Ms. Evans, please.
Yep, and I just would just remind folks, like we're not talking about like right when I said that about like holding people's careers hostage, like right now the way that it sits is that people have to run a set aside, which can take months and months and months for 7 years after release from supervision. That's the way that it stands right now. And so we have people that are trying to be employed at Minnesota Adult and Teen Challenge that have these shoplifting charges on their record that when they move from one position in our organization to another, have to do these over and over again for these shoplifting or theft under 500 and other crimes as well, for that long of a period of time, 8 years. And it just seems disproportionate to the crime when they've shown that their lives are back on track and like, so for how long? Like, what's the when is it a diminishing return on that? And I feel like what it is right now is it's too long. It's too long. Like we're wasting tax dollars, employer dollars, small business dollars. Like what it is right now is too much. So maybe nothing is too little, but what it is right now is also too much. It's too long. So,
and Ms. Evans, I mean, not to put you on the spot, do you think 5 years is a better, or do you think that's too much? I mean, you guys have a unique view because of the work that you do at Adult and Teen Challenge. What do you think is a good number?
I'm going to put it right back on you, John, because from when?
No.
Because it matters. From when? From release from supervision, from the time of the crime, like that matters. I've been asking you, like we can do this thing about, like you keep saying, like we need to know this 0 or none, but all of it matters to me because I am more of a moderate than any of you even know. Like it matters to me on this one specifically. Like if you guys are saying from the commission of the crime, then 0 is not enough. Like people,
but let's just say,
we need to know that they're not going to commit these crimes again.
Let's just say the actual time, forgetting when it starts, when it ends. It's just saying the actual amount of time. So if the event happened in 2011 and there's no subsequent anything that happens, when should that person?
I don't know. I personally would like to see a couple of years crime free.
Okay. I mean, I think tackling theft is important to us because it's just the numbers are so big. Obviously, you can see the 4,800, and the simplest thing to do is to leave it in there or put it as a 5-year. But we can be creative. I mean, we've come up with this idea of 5 and permanent, and it doesn't mean though that that's what we're going to do. We can be creative and we can be thoughtful, but obviously we don't have consensus on theft. Anybody else want to talk about theft before we kind of put a pin in it and come back to it? Because it's real important, and I don't want to go way too early, but I also don't want to spend all of our time on just one.
Mr. Chair, I would just say one final thing is that the dollar amounts can be a little misleading because these can be charged, the conduct could have been stealing a felony amount, but because of a plea deal to keep the wheels of justice moving, everyone agrees that they're going to be sentencing it as a misdemeanor. And that on one hand is saying, the state has said this person's conduct, is really only worth this kind of criminal penalty, but that doesn't actually necessarily get under the exact number of the underlying amount. So, and I think it's just I know that, Mr. Chair, having practiced in this area, but I think it's good for everyone to remember that just because someone has pled to a certain crime or level of crime, that's not necessarily an indication that that was the conduct that they were partaking in.
Thank you, Mr. Page. I mean, are there people that think that theft, any theft under 500 should not be on the 5-year list. Ms. Dawson, welcome.
Hi, sorry I'm late. It's one of those days, weeks, months.
Appreciate you making time.
I think I just go back to looking at the safety concern that was highlighted, and with theft, I think it's hard. There's a million different scenarios you could think of, but I just look at the amount of the different types of offenses. I think it can end up bringing in too much and can bring in probably good people who are perfectly qualified to do the job. And I think that that's where we're simply looking at a disqualification statute. It doesn't mean that the employer may still not hire the person. And so I think from my perspective, I even just struggle globally with having misdemeanors, other than, I guess, domestic assault in there because it's required by federal. So other than that, for me, most of these misdemeanors, they're a misdemeanor. The legislature has deemed them to be that lower level offense. They can be expunged faster. At some point, it just gets to be too complicated and too cumbersome to try to figure that out. And then attorneys like me are left trying to interpret that.
Thank you so much, Ms. Dawson. Judge Kulik, please.
I think Ms. Dawson made my point, so.
Okay, so this is a big one for us. I think we got to loop back on it. It's a tough one because the numbers are so big.
I do have one.
Please.
I want to make sure that we aren't using disqualification to repunish. If somebody has committed an offense, and sure, you can have plea deals down, but the vast majority of misdemeanor theft is shoplifting, and it's charged out at the value. So I don't see a lot of pleas down on that. And we do punish them. We require restitution. They pay a fine. They are on probation. Sometimes they do a little jail time. And if they fail probation, they can be put into jail for up to 90 days. They pay the price. That's why I don't want to repunish them by saying, and now you can't be a foster care provider, or you can't work in that adult group home over it. When you are not a safety concern, you're not handling anybody's money, and we have such an unmet need.
It's a good reminder too that this is, by definition, not about punishment. This is a non-punitive statute designed 100% to protect individuals, but never to punish anybody. These are not punitive in any way. So even if we said remove something, it's not saying you're condoning the behavior. They still would have their obligations to the court. There's so much more there. It's just saying we're not going to prohibit you from working this job. Doesn't mean you can get the job. Doesn't mean you can keep the job, but there's nothing that prohibits you, which is a really unique thing in our state, and almost no kind of statutory requirements are put together where you are prohibited from working somewhere. Usually it's really hard to get that job with a criminal record, but the prohibition and disqualification is pretty unique. Let's move on to bringing stolen goods into Minnesota. This is another case where there have been 0 cases for the 2018-2019. The definition, bringing in property into the state, which the actor has stolen outside the state or received outside the state, knowing it to have been stolen, and was sentenced as a misdemeanor. Again, very low, non-existent numbers. Anybody have thoughts on this?
It sounds more insidious than it is, because again, for it to be a misdemeanor, it has to be a very low value. And while I don't have, Although, when you only get charged with receiving when it's clear that you knew or should have known. Truly innocent people can buy the snowmobile from their neighbor or whatever, a set of tools and really not know, but they're not the ones who get charged and convicted of these. I wish there was something a little less, for that. It's the sort of thing that is not based on immediate need, like taking the diapers or the birthday presents for your kid. It's a little more thought out and long-term intentional to defraud somebody else with their property. I don't mind there being a penalty for it. I just again like it to go back to date of offense, and certainly if you talk up more, then you keep adding them up.
And this one is so we've got 19, which is bringing stolen goods into Minnesota, and 21 would be receiving stolen property. And maybe the two kind of go hand in hand. So bringing stolen goods is the act of bringing the stolen property into Minnesota. And then 21 would be essentially purchasing those things. Let's do 19 first. 0, take it off, leave it at 5 year.
I leave it at 5 year. I think that it shows it shows a calculated sort of criminal attitude. So something's been stolen, somebody's being wrongfully deprived of their property, and you are intentionally bringing it into another jurisdiction so that you don't get caught. And that, along with receiving when you know or should have known, you're part of a process that really is kind of conspiratorial. And that's, for me, that is so different than the shoplifting kind of thing.
Okay, Ms. Dawson. Oh, we might have lost you. I thought you had your hand up.
It helps if I unmute. So I think I just go back to when I look at these misdemeanors, they're not required by federal law. They're not. I think Minnesota is fairly unique in our use of misdemeanors. I struggle to see that safety connection, and especially when, I guess, if you just want to put me down for kind of a global, you can probably assume most of these misdemeanors. I mean, if we're really looking at a permanent, and I know I missed a meeting, but if we're really looking at a permanent and a 5-year ban, misdemeanors and gross misdemeanors and some of those other felonies are not even on the same level. And so I guess you can just put me down for, to me, pretty much most of these shouldn't even be on the disqualification list.
And for those who might have missed it, when you said the misdemeanors, talk briefly, if you wouldn't mind, just about the uniqueness of the Minnesota disqualification scheme as it uses misdemeanors compared to other states that you reviewed.
Well, I know when at least the remedies subcommittee was looking, I think we were, if I remember correctly, really finding it was more felony level offenses, and then the serious ones that are required for, like the Adam Walsh. I think the fact that we have gone all the way into these misdemeanors, if I remember correctly, I don't think that's what we were seeing. And to me, again, I go back, it's a misdemeanor. It can be expunged 2 years after release from probation. So somebody can go get this expunged in much less time. And our legislature, if it's deemed to be a misdemeanor, there's already that lower level of safety from the legislature's standpoint, that why not be leaving it up to the employer, and the employer can make that decision and really leave in the felony and the more serious gross misdemeanor. And again, I'll say at the domestics, because I think that those domestic convictions, I mean, they're required by the child care block grant. Just having all of these others in here, I think it's just recriminalizing and well, it's just another penalty when somebody has already That's what the criminal justice system is for. We're not here to repenalize under the disqualification statute.
Thank you, Ms. Dawson. So I think we're kind of hitting into almost really a philosophical problem where I think there's some people thinking that the misdemeanors, many of them don't make sense for public safety to retain them, leave it to the employer, and others feel that these are bad enough acts that we want to protect the vulnerable individuals. Not really sure how we move forward. I was hoping we don't have 20 come back to matters, but we might. Mr. Vogel, on 19 and 21, why don't we leave those as more discussion, and talk briefly about identity theft. Identity theft is on a misdemeanor level, is going to, I think, involve the single victim. Let's see. And it's going to be any loss to the individual's $250 or less. So that's what we're talking about, the lowest level type of case. 0, 5, or 5 years. What are people's thoughts on identity theft?
Well, it sounds more insidious than it is, except when you realize where technology has taken us. It's just a high-tech form of stealing like other things, and I don't think it warrants a different classification than other misdemeanor stealing, although we treat it differently because over 250, suddenly you're at the next level, like it's somehow worth to do this. And who knows why? There might be a rationale that I simply don't understand, but under 250 single time, I wish we had a 1 year, and maybe some of these it's off probation because you get 1 year. But I don't see a single incident as being much different. Now that isn't really an opinion, that's babbling, but thank you for listening.
My apologies, I was being called by my son. Ms. Sherlock, and then we do have to cut it out. I actually have to bring my son to practice, but Ms. Sherlock, please.
I just wanted to say, while I typically agree with what Ms. Dawson said for the most part in this area, because I tend towards, as I've made well known on other occasions, tend towards the federal requirements. For some reason, when I was going through this on my own, I thought identity theft was something a little bigger than some of the other thefts, and put down to keep it as a 5-year. I'm guessing because I thought it was probably much more, and maybe it's what Judge Kulik has said, it's like planful, like lots of steps. It's not impulsive. It's well thought out. And so, and maybe that's all changed now with the technology we have, but I think those were some of the reasons why I thought it should stay as a 5-year.
It also is, it can be very awful for the victim even on a non-financial level, trying to get stuff back, even though there's not a financial loss.
Right.
I found Ms. Sherlock to be really persuasive, and now I'm agreeing with her.
All right, Ms. Sherlock, you convinced the judge.
Woo!
It doesn't get better than that, does it? Well, on that, our hour's up, and I do have to run as well. I think we've got a fair amount more work to do. I think offline, why don't we, Mr. Vogel, when you're back in the Twin Cities, can we just have a quick call with Ms. Evans, and we'll figure out the plot and plan moving forward. I just want to thank everybody for being here. This is hard stuff, and we appreciate everybody's efforts to help figure out a system that protects the safety of individuals, but allows people who are safe and dedicated the ability to work and thrive. Okay. Goodbye, everybody.
Thank
everyone.
you. Bye.
Mr. Chair.